SJC-11189, Commonwealth v. Richard Figueroa.
Good morning, I'm attorney.
Hold on, please, 1 minute. We want to get you on tape.
Memorialized.
And, all right, we're ready to proceed. Good morning.
Sorry.
Yes.
I'm attorney Donald Harwood on behalf of the defendant appellant. This is an appeal of a conviction of first-degree murder. The defendant had shot and killed Luis El Cantaro on January 31, 2008 in Lawrence, Massachusetts at a bar restaurant called La Bahia. I wanted to discuss today three of the issues that are raised in my brief. The first one being the warrantless search and seizure of the defendant from 59 Salem Street. That's the first point in our brief. In this case, about 2 hours after the shooting in the bar, police went to 59 Salem Street on report of a taxi cab driver who said he had dropped off a fare at that location. And they didn't have an arrest warrant, as Peyton would require, and they didn't have a search warrant either for the person whom they were looking for. What they really had was a general description, and Your Honors, reviewing the evidentiary hearing will immediately note there was no actual description introduced in evidence by the Commonwealth, who bears the burden on exigent circumstances, of the shooter at the bar. What they do introduce at the hearing is they say that the taxi cab driver said that the suspect matched that which was being told him. But having scoured the record again, I see no description of a Hispanic male or anything of that sort. If Your Honors look in
from the restaurant? You mean a description that somebody gave to the police?
Exactly. That's not in the record. The best Your Honors are going to find on the show-up identification, where there also was a separate evidentiary hearing, there was a description in front of that judge about a Hispanic male in his mid-20s having been the shooter. But in the hearing with respect to the warrantless arrest and search, that doesn't come out. So
Let me ask you, do I have my facts right? Did the cab driver drive him there?
yes,
And so he had two exposures. He observed him two
dropped him
different
off,
times.
picked him up.
So he was able to describe this person to the police.
Yes, all I'm saying is no evidence was introduced that this was a Hispanic male at the arrest and search hearing. So, and the reason I mention probable cause, of course, is when you're considering exigent circumstances as opposed to consent, you have to show probable cause, and one of the factors under Ford is a very strong showing of probable cause. And even if you look at what the other judge found on the identification, he said a Hispanic male in his mid-20s, and it's clear from the trial that Figueroa is Hispanic and 43 years old.
Was the evidence before Judge Whitehead that the cab driver said that the description the police were giving him, whatever that was, the person he had taken fit that description?
Yes, he said, yes.
That's in the record.
The cab driver says he matched the general description of that which was being told him. But the police never indicate what that description is, so the court is left wondering, well, what is the probable cause here? Are they simply following every lead to determine if they can find the shooter? And at best, even if you go by the show-up identification, you have a Hispanic male in his mid-20s, which I say you can't bootstrap, but if you were to look broadly at it, and that's really, my point is, not probable cause to arrest. Here, you're breaking into a home without a warrant, and the only evidence you have is, at best, a general description, and conceitedly not one ever elaborated upon by the Commonwealth in its proofs. In any event, they get to the house.
Before we leave that, I mean, I've not looked at the evidentiary hearing yet, but I gather they had information that the taxi driver had dropped somebody off,
Yes.
that he had said, "I'll be back shortly," that a person walked into a bar or restaurant and fired shots, and that the same person who he had just dropped off came back and then wanted him to not stop at a red light, so that there was some urgency to get away from the scene.
I'm not sure if the evidence is as tongue and groove as that in terms of the sequence, like, hey, wait here, I'll be right back. I'm not sure if it was that, but it is, he dropped him off, and then shortly thereafter, it may have been a matter of 5 or 10 minutes, he sees the same guy flag him down, and he is brought to a home. But everybody's running out of the La Bahia once the shots are fired. So that's not necessarily indicative of guilt. That might be indicative of people running for
But he did
safety.
say, I could be wrong, but I thought he did say something to the driver before he got out the first time about, "I'll be calling you," or
Yes.
I'm going to be back to you. So
And then it's a question of how much later was that. So in any event, probable cause, it's not like some of the cases that the Commonwealth mentions, like de Blasio or Donahue, where you have solid probable cause. You have a description of a black male, 6'1", weighing such and such. You don't have that. In Donahue, you had a civilian witness saying, "That's Eddie, I'm going to take you over to his apartment." Here you have a very general description at best, which isn't introduced in the record, and you have police going to a house 2 hours after the fact. Now, in terms of exigent circumstances, that's obviously relevant on the showing of probable cause. When they get there, there's no risk of harm to the officers or the people therein, because they walk up to the door. The person on the first floor says, "There's somebody who matches that description who lives with the woman upstairs," but he certainly isn't saying there's any urgency or anything. It's as if they've woken him up and he's coming in with with his undergarments on. They go up to the.
there?
That's Viejo, who
Yeah,
is,
okay.
and he's
But-
on the first floor.
But he had a gun, right?
The shooter had a gun.
Yeah, well, obviously, whoever shot in the bar
Right.
had a gun. This was a shooting, not a stabbing. So
No,
yes.
but I mean, if, you got two issues there. One is probable cause, but putting that, assuming
Right.
for the minute, you're talking now about why couldn't they get a warrant? But if they've got probable cause that somebody with a gun is in that apartment, isn't that
Well,
fairly
it's like
exigent?
Tyree, in Commonwealth versus Tyree, 3 years ago, you held just because a gun is involved doesn't mean that in the aftermath of every incident involving a firearm, those were your words, that exigent circumstances kicks in. And in Tyree, like here, you had a police officer at the front door of the condominium, and you had a police officer at the back. And here, you have 8 police officers around the house. You have the police going up, and one man saying, "Yeah, there's somebody," I guess he said a Hispanic male who lives upstairs. And then when they go to the second floor landing, Nancy Alon says, "You can't come in here. You need a warrant. I don't want you in here." And they have an exchange. And then the police literally, they hear some footsteps, and they literally push her aside and run up the stairs and then find the defendant ultimately in the 3rd floor.
Can I just go back to the timeline, because it seems important to this analysis? The taxi cab driver, and I think this was at the hearing, the information is that he dropped off his fare, the defendant, and drove around the block and sees him again. So that's a very short period of time. So he drives around the block, he sees him again and picks him up. Isn't that a very short time frame? And then he brings somebody who if the police have this information and it's in the record, behave really dangerously, coming into a crowded place and shooting, and also appeared to be something, drunk or whatever. I mean, had something that was going on with him. Wasn't calmly doing this, and so if you have the time frame and assuming probable cause, that was sufficient. Why wouldn't you have exigency? Here he is, rushing
Well, because
away.
the timeline is very similar to Tyree. There you had two masked armed robbers. It's an hour and 45 minutes later that they approach the apartment that they break into. That timeline is almost exact to this. And it's unlike
Kill a bunch of people?
No, they don't.
Right, they
no,
don't.
no, they did not.
Right, right. That's the difference.
But it's two masked armed robbers going into a store, and it's approximately 2 hours later. And basically, I think it pushes that exception to the limit. It's not like the other cases where, for example, in Donahue, you had a very gruesome assault committed upon the victim, and there was almost an immediate pursuit. The other case that they cite, de Blasio, it's literally a shootout. The two perpetrators shoot two police officers. There's a blown-out window as they're chasing the car. And again, in each of those cases, they have very specific probable cause. That's, I think, what's different here. Here you have a description of, a very general description at best of a Hispanic male, had the Commonwealth put it in the record, but they didn't. So we say that that pushes exigent circumstances to its limit, that this looks much more like Tyree than it does Donahue and de Blasio. Consent is very difficult to make out on this record for the initial intrusion because they literally barge. Certainly the defendant didn't consent, and how could one, even as a
Motion
matter...
judge didn't decide this on consent, that part on consent, right?
Well, he did say that after the fact she signed a consent.
Oh, okay,
So
but
he
that's a different matter. I mean, he didn't suggest that the barging in was consented to, right?
And I'm
I
glad-
mean, at the time.
And I hope the court takes that view that you can't have an after-the-fact consent that legitimizes an initial entry.
Say that, I just said, I thought you were saying that he found that maybe it was consent in the initial entry, and I didn't read it that way.
No, but he does talk about a consent was signed
Yeah,
by
but
along
afterwards,
after the fact. And so what is the harm from all of this? The harm is the defendant is arrested inside the apartment and taken out with no probable cause, given those descriptions, and without an arrest warrant. He's then brought down, and there's a show-up identification procedure outside the house. So we say that it was an illegal entry so that the identification has to be suppressed. There was only one witness who identified the defendant at trial as the perpetrator, and it was the one who did the show-up identification. The other two witnesses who witnessed the shooting didn't identify the defendant at all. And then lastly, there's a gym bag that's seized from a closet where the defendant is arrested. They say that can be pursuant to an arrest, and they cite Netto. Netto's a case where the police had a warrant. And Netto's a case where, again, they had probable cause. We say there wasn't probable cause to arrest the defendant to begin with, so how can you justify the seizure of the bag as pursuant to a valid arrest? And of course, he was handcuffed and taken out at the time that they actually seized the gym bag and went through it and found ammunition. And I know this court has held that's not necessarily dispositive, that the defendant at that point is in custody, but still, those cases at least presume there's a valid arrest and probable cause, and that's lacking here. Lastly, the next day, they still don't get a warrant, and they go in and they search the first floor apartment and they seize a Ruger revolver. And we say that that was illegal too because it's a fruit of the illegal entry, and any consent, this is where the judge clearly relies on consent. He says that Nancy Alon, the owner of the building, consented to it.
Consent and standing.
Right. I thought he relied more on
standing.
standing.
And standing is, the evidence on that is that the defendant could freely go in and out of this apartment, and that he was the one who brought Viejo to Alon, and Viejo was occupying and living in the apartment at the time.
When was it that the defendant made the statement, I killed the guy who beat me up?
That was made after the fact to Ingalls Baez. There is a statement, and I don't remember if it's
Or is
immediate.
that the one I panicked and that's when I shot him? I think I see two statements.
Well, panicked and I shot him, that was at the trial, but there was a statement to Ingalls Baez about, I believe, about shooting. But I don't remember if that was the same night. I would have to look at the record to.
Was it a phone call?
It was a phone,
Yes.
it was a phone call in which he said, "Where are you?" And he said, "You're not my
Yeah.
friend," or something like that.
Yeah, so I think that was the same night, I believe.
Before his arrest.
Yeah.
With regard to exigency, what do you suggest the police should have done? Sort of lay siege to the house, surround it?
What this court suggested should have been done in Tyree, they could have simply, and this court said there was no risk of flight because there were police surrounding the apartment. They could have just stayed around the apartment until they got a warrant. They could have gotten
Go
a,
to the door, and the woman answers and says, "It's just me and my two daughters here." Let's assume the police have probable cause to believe that a man who just murdered someone with a gun is in the place. And they're just going to sort of surround the apartment, go to court, see if they can get a warrant, and allow these two children and this woman, who knows what the circumstances are, be in a house. She says there's no one else in here, but they have evidence that a man armed with a gun has gone into the house. I mean, I'm not. Isn't that exigency?
well, I would say that it isn't. If Nancy Alon had a fear for the safety of her children, she would have said something, but she didn't have.
Do you think
What
so?
if
How do you
he
know
had-
that?
What if he had a gun against the head of one of the kids?
Think
The
so?
evidence does not indicate that. The evidence indicates that Nancy Alon, if anything, didn't want police to come in.
That's after the
Yeah.
fact.
Because they would scare her children.
Or-
It certainly didn't indicate that she had a fear for her own safety.
So the police
or
are
that of the
supposed to
children.
intuit that.
Are you saying that the police, in those circumstances, assuming for the minute probable cause, the police are bound to believe what she says? Oh, she says everything's okay, we'll just go away? I mean, it seems to me if you've got a gun in there and two children and a woman, and that's it, they don't have that is an exigency that lets them go in and try to find that person?
If what Your Honor is saying were true, taken to its logical extension, any time that there's a shooting and any time that you go to the defendant's family home, you would be able to get into the home because there's been a shooting, and
They
if
don't
the
know
wife
it's the
shows up
family
at the
home.
door.
That's not what they have in their minds when they're told that somebody who's just killed a person, jumped in a cab and went to a place. They don't know anything about that except somebody who's just shot somebody has gone to a place. And then they go to the place, and then there's a woman who says, "You can't come in, I've got two children."
And there's no one else here.
Well, they go to the place, and the first floor apartment owner says, yes, there's there's somebody matching that description. If they have probable cause, that's, they do or they don't. And he says he lives upstairs with the woman. I mean, all I'm saying is a wife in a situation like that may say, I don't want you coming in. The violent episode may have nothing to do with domestic violence, and you would dispense with the warrant requirement in every instance.
Can we, I'm looking at that color.
Yeah.
Could we switch to the
Yes.
show up? Or whatever else you want to?
The main thing I wanted to switch to was the reasonable doubt instruction, because here, this is a case, and I don't think this court has directly addressed it, but instead of instructing pursuant to Webster, the trial court here admits that he deviated from the Webster instruction that this court has approved and indicated in Watson should be followed. And he basically blended the first two prongs of Webster with a federal instruction, which even the First Circuit has said is questionable. But the big deficiency from the charge is this: there's no language in his reasonable doubt instruction about abiding conviction to a moral certainty. He eliminates the language about all of the inferences should be found in favor of the defendant. He eliminates the burden of proof is on the prosecutor. And I cite each one of them in the brief. There are about 4 prongs of Webster which are lacking.
But there was no objection at trial.
I'm sorry?
There was no objection at trial.
No.
So how can we find that an instruction which the federal courts have adopted constitutes a miscarriage of justice?
Because Massachusetts courts, I cite the state law too, and primarily rely upon it. This court has held that reasonable doubt instructions, you give greater protection under Article 12 than the federal courts have given.
You're saying that state reasonable doubt means something different than reasonable
Yes.
doubt federally?
Yes, it does. In the federal courts, they've said you don't have to give this instruction at all. In the state courts, you've said that you do have to give such an instruction, that Webster...
Do we say now that you absolutely have to say to a moral certainty that that's a sine qua non of an acceptable reasonable doubt instruction?
In LeBron, you said you have to give its equivalent, and here, this isn't the equivalent because almost every aspect of Webster is out of this charge, except for the first sentence. So you don't have any of the 5 elements of Webster that follow. I think there are 4 of them that are lacking here. And there's no objection, but under 33E, you can consider the case broadly, and you can consider this error as well as the intoxication error, which I cite as well, where he says the Commonwealth doesn't have to prove that somebody's sober. And I argue in my brief that this diluted the burden of proof as to his main defense, which was he was intoxicated and he lacked the intent to deliberately, premeditatedly murder the defendant.
Well, your time is up.
Yes. Thank you very much.
Good morning. May it please the court, Marcia Slingerland for the Commonwealth. The record here clearly shows there was probable cause to believe that the person outside of La Bahia, picked up by the cab driver, was the person who was the shooter. I would cite this court to pages 10 and 11 of my brief, where I lay out in detail Judge Whitehead's findings. They are lengthy, and taken all together, they meet the standard of probable cause to arrest.
Well, could you tell us what the evidence was Mr. Harwood said there was nothing in the record about the description provided to the taxi cab driver concerning the person that they thought was the shooter, the police thought was the shooter.
There was not a description, there was no testimony about what the eyewitnesses in La Bahia described the person as being. However, there was testimony by Detective Hagerty, who was speaking with the cab driver, who revealed that the description was that, this is on page 140 of the motion to suppress hearing. It was a Hispanic male, short hair, average height, and a black and white sweater. There was, in addition, testimony by Detective by Detective Kelly, that the description given to him by Detective Hagerty matched that of the witnesses. So there was a conclusion that it matched.
So if I understand correctly, before Judge Whitehead, Detective Hagerty gave that description.
Yes.
And there was evidence that the taxi cab driver said, the description you are giving me is, it sounds like the guy I just picked up. And so you're saying, I take it, that there's a reasonable inference that that Hegarty's description was what was given to the taxi cab driver. Do I have that right?
The cab, as I understand, the cab driver's description was given to Hegarty, who testified at the hearing as to what that description was. There was also testimony from a different witness, Captain Kelly, who was speaking with Detective Hegarty, who testified at the hearing that the description given by the cabbie matched that of the description given by the eyewitnesses to the shooting.
Oh, it's the other way around, okay.
Of which the only thing that's distinctive, especially in Lawrence, is a black and white sweater. I mean, being a short male Hispanic does not distinguish you from most of the residents, most of the male residents in Lawrence.
Well, granted, it was nevertheless what they got in the immediate aftermath of the crime, and the cab driver was able to give that short hair, average height. I mean, perhaps there was nothing.
But it really comes down to the sweater. I mean, it really comes down to the black and white sweater, the clothing.
Well, that certainly is distinctive.
Is the black and white sweater something that they got from the witnesses at the restaurant?
There's no evidence of that. The black and white sweater also, I think at trial he testified he had when he went and ID'd him, he had changed his sweater. But at the motion to suppress, there's really nothing about the sweater except that testimony by Detective Hegarty.
I mean, is a description even necessary? If the police say, we got a description from the eyewitnesses, we talked to the cab driver who picked someone up right in front of the place or right at the place, right afterwards. The description we gave him from the witnesses matched the description the taxi driver said got into the car. We then went to the place that was where he was dropped off. We spoke to the man on the first floor, gave him the description that we got from the witnesses, and he said, yeah, that guy's upstairs, lives upstairs. What difference does it make if the details of the description, if the testimony is it matches each way down the road?
I would agree with that totally. That's what the record is, in fact, here. And
Unless
there's
it was so
cumulative.
generic, unless they're relying in each case on something that's so generic, it was Hispanic male.
Well, again, you have to look at the circumstances as they face the officers at the time. They have, in addition to this matching description, they have the information from the cab driver that that when he dropped off this person, he told him he was going to call him back in a few minutes. Right. So he's anticipating a short stay. The cab driver drives around the block and was flagged down by the guy. Again, a short period. The guy gets in the car and urges him to run a red light. Again, showing the urgency and the unusual behavior of this individual. Then Viejo, the man on the first floor, seems to understand that the police are talking about somebody who, I think the testimony was, fits generally the person that has who stays with the woman upstairs. So that basically, all that taken together, as the police look at this and they're faced with a shooting, no gun is found, there's a guy being attended to by EMTs, it's clearly a serious violent crime, and a missing gun. The police are faced with these circumstances that they need to deal with. When they do get to the door, they hear, when they get to the door, the second floor, they hear a door slam and running, despite the fact that Ms. Alon had said that it was only her and her children there and that her children were sleeping. So it makes no sense, I'd suggest, for the police to have surrounded the house when you've got a man, a serious man, probably armed, in a home with women and children. The defendant cites as authority in his brief a number of cases that deal with the emergency exception, which I'd suggest is different than the exception found by the judge here as being satisfied, probable cause and exigent circumstances. This was not a situation where they were only concerned for the safety of the people inside, but they were also pursuing an investigatory purpose. With regard to the question of the search of the duffel bag, I would suggest that It was certainly reasonable here. You have a missing gun. It was found, the duffel bag was within 5 to 6 feet of the defendant when he was found.
Are you saying it is a search incident to arrest?
I am, under the Netto case. I would note also that Judge Whitehead noted in addition to that, from a broader perspective, there were other exigencies that justified the search, because you have people in an apartment and a missing gun, and you've got a bag that was right close to the defendant. It certainly would have been reasonable to search that bag. It was limited in scope, and it occurred at a time when the danger had not been dispelled. So it clearly was reasonable. With regard to the issue of the defendant's consent, the judge found that her consent, that Ms. Along clearly had the authority to consent to a search of the entire premises. She owned the entire house. She didn't care what they looked for as long as they didn't make a mess. That's in the judge's findings. And that he made that from the tape. I have asked that the tape of her, they recorded her giving of the consent. I've asked that that be forwarded to this court so that you can hear the tone of her conversation with the police as she signs the consent form.
So the significance of the consent is what? The day after search of the first floor?
Well, the judge finds it significant in that it would inevitably have been discovered by the consent of Ms. Alon.
What, the stuff in the bag?
In the bag
Okay.
that was found that night in the duffel bag. He did mention that her consent could have covered as well the search the following day. It was a broad consent. It wasn't limited in any way. And it could have covered the search of the first floor apartment. However, he also found, and the defendant, I don't think, seriously contested this in his brief, that there was no legitimate expectation of privacy for the defendant in any contents in that first floor apartment.
And he wasn't charged with a possessory offense, so the automatic standing rule doesn't apply.
Correct.
I take it the gun that was found was not able to be matched to the fragments of the bullets. Is that correct?
At trial. There was testimony at trial that the ammunition found in the duffel bag matched that in some way of the gun that was found in the first floor apartment. I believe that the forensic testing of the bullet fragments at the scene, they were not able to match with the gun.
Well, let me ask you this. Was it this is not a match, or because of the fragmented pieces of the bullet, we're unable to make a match?
You know, I haven't focused on that aspect of it, but there was, I'm not sure, I just know there was not testimony at trial that matched the bullets at the scene.
And I take it the defense at trial was not that he didn't do it.
Correct. That's right.
he
It
was-
was solely, really, it was that he was intoxicated, and in his closing, the defense counsel asked for a second-degree verdict return.
If I could turn to the Tui Rodriguez issue. Is a jury hung or at issue when the only thing they cannot decide is the degree of murder? I mean, we certainly would be concerned to declare a mistrial if the jury said we can't decide whether it's between first and second degree, but we all agree it's second degree. It's at least second degree. We'd have a lot of mistrials if that were the case.
Well, the question, I think if you consider the way the judge, what the question was if the jurists cannot agree on first-degree murder, i.e., some feel is it first degree, some feel it is second degree, are we a hung jury, or do we move on to consideration second-degree murder? So it's their perception of their situation. And the judge discusses this with counsel. And at pages 26 to 28, I show the exchange of my brief. I show the exchange of the defendant's responses to the judge's questions. He appears to agree that the jury is hung because they can't decide. And the judge ultimately answers the question using the principle that the jury have a duty to return a verdict of guilty of the highest crime that was proved beyond a reasonable doubt. And therefore, he said, he gives them that pep-up charge as to first-degree murder because he concluded that they needed to be unanimous, either guilty or not guilty, on first-degree murder before they moved on to second-degree murder. And he, in fact, had instructed the jury to that effect earlier in his instructions, and there had been no objection.
But is that right, though? I mean, do we want to declare a jury in a murder case to be hung because they cannot decide whether the person commits first-degree murder, even though they all agree it's second-degree murder?
Well, the question indicated some felt it was first degree, and it didn't indicate that they all felt it was second degree, but some felt it was.
But realistically, I mean, there was no defense here that he was not guilty. I mean, he conceded.
It was the
essentially.
degree of murder that was at issue.
I mean, this is an unusual case in that regard, but I mean, you can understand the concern that a whole lot of juries find second degree, even though there may be some jurors who would say he's guilty of first degree. And I don't know that we want all those juries to come back as a hung jury and then do a retrial.
I understand what you're saying. I just think in the circumstances of this case, the judge answered he was concerned about answering their question, which was, are we a hung jury? And everybody agreed, yes, you are. And then the question was, what do they do next? And the judge, I suggest the Anderson case that was cited in the Mao appeals court decision case talks about the appropriateness of instructing juries to consider degrees of offenses, particularly murder, based on the most serious charge first, and in descending order of seriousness. With regard, were there any other questions on Tui Rodriguez? I'm happy to address the reasonable doubt claim. This court, I believe, as you're well aware, has never required that any particular language be given. This court has, in fact, cited favorably in Commonwealth versus Therian, which is at 428 Mass 607, the second Therian. And in footnote 5 there, this court cited with apparent approval instruction 21, which is the instruction which Judge Welch gave in this case. In addition, you have the authority of the Hurd case from the appeals court and the LeBron case, also from the appeals court, 2006, in which it notes that instruction 21 in and of itself is sufficient to constitute a proper reasonable doubt charge. Finally, I would cite you to the Commonwealth versus Bain case, which was decided by the appeals court in March of 2013, and further appellate review was denied by this court on June 6th of 2013. Here, the judge gave parts of Webster. In my brief, I've omitted one of his paragraphs, so I would just direct you to pages 115 and 116 of transcript 6, where the whole charge is laid out. But you can see from the entirety of his charge that he doesn't lower the burden of proof. There's no way that the jury could have misunderstood this high degree of proof that they must find before convicting the defendant. The judge also was careful to say that the verdict has to be based on the evidence. And really, that's the problem with the moral certainty language, which the U.S. Supreme Court in Victor v. Nebraska expressed that it didn't like the term because the jury might misunderstand it unless it's adequately explained. The Hurd court said they understood this court to be acceptive of instruction 21 from the federal criminal jury instructions. So the judge was careful to say the defendant is presumed to be innocent. The Commonwealth bears the burden of proof. If you can draw two equally reasonable inferences, one favoring the defendant, one favoring the Commonwealth, you have to favor the defendant. Because the Commonwealth bears the burden of proof. He reiterated that the verdict had to be based on the evidence, not sympathy or emotion. So his use of the words, you have to be firmly convinced that the defendant is guilty, and you must acquit if there's a real possibility that the defendant is not guilty. The use of those words are consistent with the Webster language. And I'd suggest that there's, based on the authority I've given in my brief, that instruction 21 should be accepted.
Thank you, counsel.
Okay, thank you.